Top moments: judges lost their temper in court during high-profile trials. It's not surprising that trials can get dramatic. I mean, you're dealing with tough subject matter, high stakes, emotions, different personalities, and we have seen our fair share of some of these intense moments here on Long Crime. So what we figured we would do is do a recap of some of these unforgettable incidents. And we're going to start with 5 times when judges just lost it. And we'll start with a recent case of ours. Number 5, Alex Jones. And we saw this play out in the Alex Jones case. So, as you might recall, the InfoWars host had been sued by multiple people, primarily the family members of those who lost loved ones in the Sandy Hook Elementary School shooting after Jones repeatedly and publicly called the shooting staged and fake and filled with crisis actors. And during Jones's Connecticut trial, he was represented by well-known lawyer Norm Pattis. And Pattis and Judge Barbara Bellis, well, there were some rocky moments. He's not an expert. And so, what one does is, right. How many times do I have to say when I'm speaking, you stop? You have been a member of the bar for a long, long time, and you know the rules. And even during a sidebar, when the mics were turned on, listen to this back and forth. I'm not going to have a comment anymore. I'm not gonna have it. I'm not going to have it. Do you expect me to lay silently when they're directed at me, but inappropriately? Do you expect me to roll over for my client? It's not going to happen. As I said before, strong personalities, drama, it happens. By the way, in that particular case, the jury awarded the plaintiffs almost $1 billion in damages. Really just a remarkable, remarkable case, and I encourage everyone to go back to listen to our sidebar episodes on it. But okay, we can't talk about judges losing it without addressing something that recently happened that took a whole other level. Number 4, Henry Segura. Now, sticking with defendants taking the stand, we covered the retrial of Henry Segura. Now, Henry Segura was charged with the horrific murders of his girlfriend Brandy Peters and her 3 children, including his own 3-year-old son. The prosecution said that the motive here was a dispute over back child support, a really, really terrible situation. But it was an interesting case because the defense had suggested that the murders were actually a hit carried out by a drug syndicate. And what we saw was a retrial. It was a retrial because the first trial ended in a hung jury. And during this retrial, at one point, Henry Segura decided to take the stand. And when he was questioned under cross-examination by the state, he and the judge got into a bit of an exchange. Yeah, that's very clear. Tense. Very, very tense. And for Henry Segura, he was ultimately convicted and sentenced to life in prison. I would tell you, there's just something jarring about hearing a judge yell, right? Because we don't really see it that often. But sometimes, look, judges are human beings, and they can only take so much. Number 3, school shooter. During the sentencing hearing for the confessed Parkland school shooter, the shooter pled guilty to 17 counts of murder and 17 counts of attempted murder for opening fire at Marjorie Stoneman Douglas High School back in 2018. And at this sentencing hearing, victims' family members were able to provide statements to the court. This is very typical. We see this a lot of times. This trial, this case was very different. This was just an absolute massacre, and you can imagine these parents and loved ones have very strong feelings. And yes, they certainly directed their comments towards the defendant, but they also directed their comments towards the defense team, and they attacked them for their trial strategy and their behavior in court. And the shooter's defense attorneys took issue with this. They believed that the court should step in and stop it because traditionally these statements really aren't focused on the defense team. They're focused on the defendant. And in fact, the attorney suggested that these comments were dangerous because they were directed towards their children. And during an argument with Judge Elizabeth Schurer, the judge started seeing red. I have no problem because I have big skin, but once you bring in my children, I think that's highly improper. For them to comment on my children is highly improper before this court to allow that kind of testing, okay? That just violated about every rule of professional responsibility that I have never. If you're going to get up here, and you're going to, because I asked you to go sidebar on this matter. You sidebar or not, you don't have one of your assistant public defenders say something about my children. Just that same venom that the court is expressing is the same venom that defense counsel had to sit through this entire morning. Up her children, multiple times during the trial. Nobody knows if I'm barren or not. They don't know about my children. Sit down. And look, there's a difficult question here under the law. Should parents be allowed that much free rein to go after the defense counsel? Did the attorney act improperly with his statements to the judge? Did the judge fail to show judicial temperament? I think what we can say is that none of this is surprising, in that this was an incredibly emotional and difficult case that lasted 3 months. And for the families, they were experiencing this for years. Number 2, Christmas parade. Now, this was the man who was on trial for driving his car into a Christmas parade out in Waukesha, Wisconsin back in November of 2021, killing 6 people and injuring dozens of others. And what made this trial very unique is that Brooks decided to fire his defense counsel and represent himself. And not only that, Brooks identifies as a sovereign citizen. This is someone who doesn't believe that the government has authority over him. So what we ended up seeing was just nonsensical legal theories and arguments from Brooks, but also incredibly tense moments between him and Judge Jennifer Darrow. And I will tell you right now, I have never, ever seen what I saw in that courtroom. Brooks was so disruptive of the proceedings. He would get into fights with the judge, and he would bring up things in front of the jury that he wasn't supposed to. And on one particular occasion, this is the one I'm going to bring up, Brooks took issue with how he was provided paperwork, and the judge wasn't having any of it. And that is just a sampling of what we saw between them. You know, Brooks would be kicked out of the court multiple times. And this all ended with Brooks's convictions across the board. The jury found him guilty of 76 criminal charges, including 6 counts of first-degree intentional homicide. And he faces life in prison. Number 1, Kyle Rittenhouse. Moving on, let's go to the Kyle Rittenhouse case, a very high-profile trial of the 18-year-old, also out of Wisconsin, who was charged with first-degree intentional homicide, reckless homicide, attempted homicide, and reckless and endangerment for opening fire during a night of civil unrest out in Kenosha. In this trial, this case raised important questions of self-defense after he shot and killed 2 men and injured a third. Now, in this interaction, Judge Bruce Schroeder took issue with how prosecutor Mark Binger was questioning the defendant, who decided to take the stand on issues that the judge ruled were inadmissible at trial. Now Binger says, well, look, Rittenhouse opened the door to this line of questioning with his responses. Let's just say Judge Bruce Schroeder, didn't quite agree. Men was the subject of emotional, and I'm well aware of that. And the court left the door open for me, not for you. My understanding is you should have come and asked. Why would you think that that made it okay for you, without any advance notice, to bring this matter before the jury already? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, well, I'll leave it at that. So, I don't know what you're up to, yeah. The defendant was you, the exact same weapon. He was using it in a manner to try and protect property. He wasn't theirs. Your Honor, with all due respect, I'm not going to rehash the motion. Yeah, that's true. There's no. It's a record. This was a moment for sure. And you know, this case would actually end in Kyle Rittenhouse's acquittal. This turned out to be a case where a defendant taking the stand seemed to pay off. Did you like it? Tell us what you think of the video in the comments section below, and don't forget to subscribe to our YouTube channel for more interesting videos.